even though I'm a new senator to the State House, I've been around for a few years trying to advance certain legislation. And Greg and I partnered a few years ago in 2019 when the city of Sandpoint and the festival at Sandpoint, if you're not familiar, that's a public park in Sandpoint, and they have a special event permit every year for the festival. So War Memorial Field is the park. And by means of the Festival Corporation, which is a private organization, decided that they were going to bear arm carry, and they started wanting people back in 2019. And when they started wanting people, that's when Greg was out at different county fairs, I believe, at the time, looking for that kind of a thing, where on public property we're banning firearm carry because of our state preemption laws, where the legislature gets to dictate policy about firearm carry, and none of the local municipalities should be doing that. That shouldn't be happening. So we tried to work with the city of Sandpoint back then. We emailed them and tried to get them to stand down on the gun ban, and they did not. And then the county actually filed a lawsuit because I went with my firearm with another friend of mine with his firearm to see whether they were going to enforce that ban. They did enforce the ban. We were not admitted to the concert. And so we were planning possible legal action, but of course you always want to give them a chance to change their minds. And we did that. And then the county, Bonner County, jumped in and filed a lawsuit in our place. And then they went a different route in their lawsuit, and the judge dismissed the lawsuit. Then we filed our lawsuit with the Second Amendment Foundation, and that lawsuit was also summarily dismissed by the judge, and we have our hearing on February 6th at the Idaho Supreme Court. So that's coming up in less than 2 weeks. I didn't even look at the calendar of when that is. So that's how long Greg and I have been working together on firearm issues in the state. So now that brings us to this year, and I find myself in the Senate, and we are always looking for ways to advance Idaho and make sure that we're one of the leading states on defending your right to keep and bear arms, and that is an individual right. So it's in the state constitution, it's in the federal constitution, it's easy to refer to it just as the Second Amendment, but it's in both places. It's a solid, foundational, God-given right that it's the duty of the state of Idaho to make sure that we can actually keep and bear arms should it be necessary. Over the last couple of years nationally, we've seen that as good as Idaho laws are, we've seen a couple of circumstances around the state nationally over the last couple of years with Mark McCloskey in St. Louis, Missouri. I'll kind of refresh you there. And I don't know every circumstance of that situation. This is what I always say. It doesn't really matter a person in the United States or in Missouri likes what Mark McCloskey did. The question is what should it be protected? Was it lawful behavior? So what Mark McCloskey did is he was in a private gated neighborhood. This may bring it back to your mind. And his wife and there was some BLM protesters that came through the gates of their private gated neighborhood and were coming through the neighborhood. And Mark and his wife were concerned for the protection of their property and also for the protection of their lives, perhaps. So they decided to come outside of their home on their property, and they displayed a firearm. Well, Mark got charged with a felony for doing that. And he ended up pleading to a misdemeanor. So he ended up with a criminal conviction out of that. And then we also saw the case of Kyle Rittenhouse. In his case, you probably have all seen the videos. And the prosecution had access to those videos. And whether you agree or not that Kyle Rittenhouse should have been out that night doing what he was doing, I like to say that's not for us to determine. Each person has an individual right to keep and bear arms, to protect their neighbor, to protect themselves, to protect. These are fundamental rights. If you didn't have the right to protect property, you wouldn't have property rights. If you didn't have the right to protect your own life, there's no right to life. So this right that we have to keep and bear arms goes beyond the Constitution. As I said before, it's a God-given right. It's a fundamental human right. Kyle Rittenhouse found himself the subject of an aggressive prosecution. He was incarcerated So he was deprived of liberty over a long period of time. It cost him a lot of money to defend himself in the courts. And in the end, he was found not guilty. And the reason is because the jury believed that he was exercising lawful self-defense. So in Idaho, we have excellent stand your ground laws. We amended our code in 2018. It includes the fact that if you have to use the threat of force, that you are protected by our current law. That is already in Idaho code. You do not have a duty to retreat in Idaho. If someone breaks property, it's presumed that they are going to commit a felony, and you are within your lawful right protecting your life, property, or those around you to exercise deadly force. But what if you're like Mark McCloskey and you exercise just the threat to use deadly force and you get prosecuted? Or what if you're like Kyle Rittenhouse and you exercise lawful deadly force in self-defense and you get aggressively prosecuted? These cases are what led us to draft Senate Bill 1004, which is our stand your ground enhancement. And I'm just going to briefly walk you through the two major things that this bill does. Okay, number one is, and I'll give you the language, a person who uses or threatens to use force as justified elsewhere in Idaho code, including our stand your ground laws that we amended and improved in 2018, is immune from any criminal prosecution for the use of such force or the threat of force. So we basically are creating this self-defense immunity in Idaho code with this bill. Now here's the two big parts to it though. What if you have an aggressive prosecutor? So prosecutors around the state are elected in their counties, and some of our counties are great conservative counties, and we have good conservative prosecutors who highly respect the Second Amendment. But now let's think about some of our larger cities. There's only a couple of those, and they have city prosecutors. There are county prosecutors. At this point, Boise pretty much dominates Ada County, and I'm not saying there's anything wrong with the Ada County prosecutor's office right now, but what if, and I'll plant this seed in your mind, it doesn't take a lot of money to win a county prosecutor's race. They run for election. So what if interests that were against the Second Amendment decided to fund a county prosecutor who did not believe in the Second Amendment, and they decided to get very aggressive in their prosecutions against people who used their firearm or needed to display their firearm in a legitimate self-defense, lawful self-defense situation, and that person right here in the state of Idaho could end up prosecuted. This bill basically is going to give that person opportunity to be heard very quickly in our courts so that they're not sitting in jail a very long time, losing their liberty while they're pre-trial. And so it's not costing them a lot of money for their defense with their attorneys. So what this says is, number one, and it actually is sort of toward the end of the bill, is it basically will require, it'll give a vehicle, the legislature has to put this into code to enable the court system to do this. And what was that? The court shall hold a pretrial immunity hearing within 14 days after a defendant, so this is a defendant who's been charged with a crime, after that defendant has filed a motion to dismiss on the basis of self-defense immunity. So that defendant, through his attorney, is going to file a motion for this pretrial hearing. The court is, within 14 days, is going to convene that pretrial hearing. And then we state that what has to happen in a trial hearing, I'll sort of explain, when a person gets arrested, they get arrested and charged on the basis of what we call a standard of evidence of probable cause. It's probable that what they did was unlawful. Then we have other standards of evidence. As we go up the ladder, if you're all the way at trial, in order to convict you of an actual crime, we're at the top of the level of evidence standard, and that is that it has to be proven that you violated the law and you committed a crime beyond a reasonable doubt. But before that standard, in above probable cause, a standard called clear and convincing evidence. It's a very high standard of evidence, but it's not at the level of convincing a jury of actually gaining a criminal conviction. So we put in this bill, Senate Bill 1004, that at this special hearing that we're now creating, that the judge has to grant within 14 days, that the prosecutor who's prosecuting you, in order to sustain the charges and continue with his prosecution, is going to need to up his burden of proof to the court. He's going to have to raise his burden of proof to the level of clear and convincing evidence. That's going to make him do a lot more work. He's going to have to prove a little bit more without showing all of his cards in order to continue to prosecute a lawful self-defender. If he can meet that standard of evidence, he can continue in his criminal prosecution. So let's say then that he meets that standard. So that's our first out for the lawful self-defender. We want that to be an Idaho code. Let's say he meets that standard. And the prosecution continues, and you end up as a lawful self-defender all the way at the end of the line at jury trial, or at a trial before a judge, most likely a jury trial. And let's say, just like Kyle Rittenhouse, after all that effort and all of your expense and your time lost, that you're found not guilty. We are now going to, within that action, direct the judge to poll the jury as to whether their finding of not guilty was based on your lawful use of self-defense. And it's a simple yes/no question. Did you find this person not guilty because they used lawful self-defense? And if the jury comes back and says yes, then within that same criminal action, the judge is going to be authorized to award that defendant, now been exonerated, costs, legal fees, time lost. Now, of course, the benefit of that is you just picture your lawful self-defender. If this was not in place today, Kyle Rittenhouse lost a lot of time. It cost him a lot of money. What's his recourse at this point? He could file a suit that prosecutors have immunity. So he could file a suit, but what does he have to do in that case? He's got to go find a new set of attorneys that specialize in civil law, claim that either Idaho code or his civil rights were violated. And I told you that our action with the Festival of Sandpoint occurred in August of 2019. And here it is, February 2023, February 6th, in 2 weeks, and we're now getting to the Idaho Supreme Court. That's 3.5 years. So what this will do is enable within that same action so that that defendant, who probably has no money left because he just spent all of his money defending himself in a serious criminal trial, his life, within that same action now, he's going to have the ability to be awarded costs. And what this is going to do for the prosecution, having this in place and all, is county prosecutors who are maybe politically motivated against the Second Amendment and your right to lawful self-defense are going to step a little more carefully before they enter into these prosecutions. They're going to make sure their I's are dotted and their T's are crossed well ahead of any far down the road. Because at this point in this serious of a trial, costs could be significant. And that's going to have to come out of the county taxpayers' budget. And that prosecutor is accountable to those voters at the next election cycle. So if the voters care about the Second Amendment, and if they care about their wallet, they're going to ask their prosecutor to step very carefully around the use of lawful self-defense and to avoid aggressive prosecutions when there is a very meritorious of lawful self-defense. So that explains the bill. That is pretty much all that is in Senate Bill 1004.